Hi, my name is Elizabeth Blandon. I'm here for Blandon Law to explain a very important part of the naturalization process. Naturalization is the way that a person becomes a citizen of the United States, and there are several things that are necessary to become a citizen. But one of the most important ones is good moral character, and I'm going to hope to explain what that means. Importantly, it's important to remember that you don't have to have good moral character all your life. People understand that mistakes are made, so immigration is not going to penalize you necessarily for prior mistakes. What we're looking for is whether a person has good moral character for what is known as the statutory period. Remember it as the prime numbers. That's how I like to think about it. In other words, a person who's in the military and who is applying for citizenship has to have good moral character for 1 year prior to application, all the way up until the day of the ceremony that they become a citizen. For a spouse of a U.S. citizen, that period is 3 years prior to applying for citizenship, all the way up until the day of the oath ceremony, which is the day they become a citizen. And for everyone else, it's usually 5 years. So, another important thing about good moral character, what we're looking for, is to know that it's not just convictions. So when an applicant is asked, well, is it important that I was arrested, even if it was not, I was not charged, or the arrest was expunged, or any kind of idea that you can think of? Yes, it does matter. So we're looking for convictions, arrests, expunge, nol pros, all that stuff. In fact, when you're going to be applying for your naturalization application, they're going to want copies, certified copies of all arrest or incident reports and all certified copies of all court dispositions. Okay? And I'll explain a little bit further why. But just for you to know, and by the way, not only is it arrests, it's also if you admit something at the immigration interview. So if they ask you, have you ever committed an offense for which you were not arrested? And you say, yes, last night I smoked marijuana. Guess what? You just admitted to a controlled substance offense, and that will affect your naturalization application. Number 3, let me explain the major categories. These are the major categories as to why a person may not be given citizenship through the naturalization process. The major categories of what are known as crimes involving moral turpitude is the most common one that we come across. So the first question will be, do you admit, or were you arrested for, convicted, blah, 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 of a crime? And then we have to find out if that crime is a crime of moral turpitude. Any offense that the sentence for it is less than 6 months doesn't count. So let's start with that right now. The smallest thing, an offense, it's called a petty offense. Less than 6 months of jail time, even if you didn't serve it, even if the sentence was suspended, but that's what you received, doesn't count. On the opposite side of that spectrum are the massive, what I call the massive crimes. We're talking murder, rape, certain things that are known in immigration as aggravated felonies. There are over 20 of these, and they are actually in the law. If you have an aggravated felony, you will never become a citizen. Anyone who's ever been convicted of murder will never become a citizen, so those are permanent bars. In between are a whole host of crimes that what immigration is going to be looking for in the general sense is moral turpitude. And that's a very strange way of saying deceit or an intent to somehow have, in other words, it's something other than recklessness. It's something a little bit farther beyond that. So there's a whole host of crimes, and if a person has been arrested or admitted any kind of crime or offense that involves fraud or deceit, then it would be very important to go see an immigration attorney, because that attorney will then have to research whether that offense, whether you're going to have to wait until after the statutory period or not to apply for citizenship. In most cases, the answer will be yes, but only an attorney can tell you for certain by doing the research. Another general category of offense that might make you not eligible for naturalization is what is known as false testimony on immigration forms specifically. So as I mentioned, generally being reckless is not a reason. If you recklessly committed a crime, that's generally not a reason for you not to become a citizen, with the exception being immigration forms. If you recklessly allowed a notary to put incorrect information on a form and you recklessly sign that form, you can not become a citizen because you gave false testimony to the immigration authorities. So that's very important to know. Be very honest with your immigration attorney who's doing your citizenship about all prior forms that you signed. And last, important to know, there's always that all-encompassing discretionary category. So this is every reason why an immigration officer might deny citizenship, not necessarily for an offense or not necessarily for a crime, but for things that might result in a denial. And again, keep in mind that all of these things have to have happened during the statutory period, the 1, the 3, the 5. Let me give you some examples of discretionary. A DUI, driving under the influence. So one DUI is probably not going to get your naturalization denied, but if it will get your naturalization denied if it seems like it's a pattern of alcoholism. If that was one DUI during the statutory period and then you have 4 DUIs in the past outside the statutory period. Another discretionary thing that's a real problem sometimes, failure to provide child support. Okay, even if you're currently if currently you're providing child support, if there was ever a period where you were in arrears, that is considered a period during which you were not in good moral character. And another discretionary offense that is not seen very often, but it is important, is one that they call adultery tending to end a marriage. So if the applicant was in a relationship with someone who was married and the immigration officer figures out by the dates that the other person ended the marriage, terminated the marriage, obtained a divorce or an annulment after starting the marriage with the applicant, that might also be a reason to deny. Again, it's very important to keep in mind that all of these offenses, what they're looking at is to see if they occurred during the statutory period. What I call the 1, the 3, the 5, which means basically 1 year if you're in the military, 3 years if you're married to a U.S. citizen spouse, or 5 years for everyone else. Okay, and again, it doesn't matter whether the offense, you were convicted for it, or you admitted it, or what's called nol pros. Nol pros means basically that even though the offense was committed, the prosecutor decided not to bring charges, that the offense was not basically worth their time and money and expense. So they'll just decide, no, we're not going to go forward with these charges. I hope this information has been of value to you, and here at Blandon Law, we're always looking to inform and protect in an effort to open the doors to your success.